If you come up with this child support agreement, can the court reject your agreement? Hi, I'm Alicia Kinchel, the owner of Kinchel Law, a family law practice based in the Philadelphia area. Now, at times, parties may decide to come up with their own child support agreement. We're going to talk about what happens when that situation happens within the court versus outside the court, and whether the court has the authority to reject your agreement. Now, when it comes to child support, it's important to remember that the child support is the right of the child, not the right of the party who's receiving the child support to receive it. With that said, that generally the right to receive child support cannot be contracted away either by either parent. Now we think about, well, there are prenuptial agreements, right? There are divorce agreements, and sometimes those things will have provisions in them that will deal with child support. When we look at those types of agreements, generally the court is going to look to whether or not those agreements were done with some type of fraud, coercion, or whether the terms of them were done in good faith. Now, as always, you want to speak with an attorney licensed in your state about the facts specific to your case. And the video that we're sharing today is for informational purposes only. But when it comes to agreement, generally you can have provisions for child support, but the court is looking at whether or not it's fair. Now, a lot of parties never come into court. They make up their own agreements when it comes to custody or when it comes to child support, and it works perfectly for them. And at times, parties may start out that way, something changes, and they find themselves in court, either because the one party stopped giving it or they're not feeling like they're getting enough, whatever it is, they can end up in court. Once the court has control or authority over child support, there are some things that need to be considered. So in Pennsylvania, there are generally two steps to a child support award. The first step is to go through the domestic relations office, and that's where you're going to have a conference officer help determine what the appropriate amount of child support is going to be based off of the guidelines. And again, in Pennsylvania, we use guidelines to determine the amount of support. Now, the issue here, and I think what affects most people dramatically or can affect them dramatically, is that when you have a conference officer, they don't have the same authority as the next step, the master's level, which allows them to take into consideration a lot of other things. Whether one person is really actually working to the full capacity, whether there are extraordinary expenses that one party may have. What they're really looking at, because they don't have the authority to make those types of decisions at the first level, is basically what is your income that you're reporting or that we can find, and what is the income that the other party's reporting or that they can find, and generally who's paying for medical insurance and what type of childcare is involved. What things do you guys agree on are expenses that could or should be included in the initial determination for support. If you guys disagree on that, or if there are things, like I said, outside of what I just mentioned, and as an aside, maybe other minor children that the person paying support may have. Aside from that, there's not a lot that court may take into consideration. So you find yourself needing to get to the master's level. However, what often happens, or what I see often happens with people who are not represented, is that the numbers are ran. So that's a term that the courts often use when a domestic relations officer will go back and take those calculations and tell you what the support looks like. And then ask whether or not the parties want to come to an agreement. Now, sometimes the support conference officer is going to do that and tell the parties what it is. Sometimes they may ask before I even get to the numbers, do you guys have an agreement? And the issue becomes, we're talking about, can the court reject your agreement? The issue really comes down to if the person who's agreeing to receive support is receiving or will receive a number that is substantially less than what the guidelines would suggest. So there is no hard and fast number, rule, percentage about what is substantially. But we can kind of guess at that, right? We can think about a situation where maybe the guidelines suggest that the amount of support that that person may be able to receive is $1,500, but they're accepting $200 from the other party because they have no idea maybe what that other person's income is. They have no idea what the guidelines would even suggest because they didn't do the calculations themselves that they could get. All they're looking at maybe is what they've received in the past, or maybe what they're receiving from a different person, or what somebody else in their life has received. That's the only, that could be the only foundation they have for what is an appropriate amount of support. And in that situation, if the court knows that, okay, this income that this person is receiving and this income that the person who's going to get the support is receiving would potentially entitle them to a much greater amount of support, the court can reject that. And that is because the agreement, even like it's an agreement through divorce or a prenuptial agreement, it really needs to be fair and reasonable. And a substantially lower amount than what the guidelines suggest generally is not fair and reasonable. So it's important to understand that you may um, come into court with the idea that, oh, this person may not be aware of how much I'm making, and I can get whatever I want to get or give them whatever I want to give them. But if the court is aware of it and they understand what your income is, they understand what her income is or his income is, whoever's receiving the support, the court can reject your agreement. They can put in an order for child support, at least an interim order, and may send you off to the masters. And again, the masters can do the same thing. If the master sees that the agreed upon amount is substantially different than what the guidelines would suggest, the master can do the same thing. Here's the thing though. We all understand that scenarios are different. We understand the guidelines are supposed to entitle people to receiving support that is pretty much the same for similarly situated people. However, income is not the only factor that determines how much a person can pay. Expenses are. The problem is that there are not a lot of the expenses that people have in their everyday life are not always the expenses that the court will use to deviate or go against what the guidelines suggest. Someone with an exorbitant student loan debt, someone with maybe two mortgages on their house, maybe someone who's taking care of another party. These are things that the court can consider but does not have to. And that's a situation where an agreement might be really helpful because it gets a little bit to the heart of what a person can actually afford in their current situation, especially if they're in a situation that is not easy for them to get out of, like a mortgage, like a lot of student loan debt that can't be discharged in bankruptcy. So again, agreements generally need to be equitable. They need to be fair, reasonable. They can't be done under fraud, can't be done under coercion. That's contract law. That's not even family law. That's contract law. And that's why the court can reject some things that are in contracts or agreements that are not fair or right based on contract law. All right, I hope that shed a little bit of light onto court's ability to reject agreements between the parties for support. If you have any questions about this topic or any topics regarding custody, divorce, and support, make sure you put them in the comments below. Remember to speak with a lawyer because I'm not your lawyer unless you hire me to be that. And if you do want to hire me, in the show notes, I'll have information about how you can do that. Until next time, take care.